SJC-12447, Daniel No, number 5340V, Sex Offender Registry Board.
Mr. Bova, welcome back.
It's nice to see your eyes again.
Been a long time.
May it please the court, Christopher Bova on behalf of the defendant appellant, Sex Offender Registry Board. Your Honors, we already talked about some of the issues at play in this particular appeal, mainly the locus of the burden as well as the right to counsel.
Before you get there, I was a bit perplexed by the argument that we should declare this case to be moot. I thought you needed us to decide this issue because all these folks are waiting. So if we declare it moot, the issue does not get decided and you remain in limbo. So why are you asking us to do that?
I think the purpose of the mootness argument, Your Honor, is mainly to bring to the court's attention the procedural history of this case, so the court is armed with all the procedural facts to make that decision.
Do you really want us to declare it? Do you really want to win on that argument and have the issue remain undecided?
Without conceding the issue, Your Honor, I'd say the board certainly recognized the importance of this particular case. And
but isn't one of the reasons that you're giving because of the backlog, it's not just trying to catch up with the clear and convincing initial standard, but because you haven't had a burden to apply?
Again, I'm not pushing the mootness argument.
No, I know, but I'm trying to understand it. One of the reasons that you're behind, I think I read in the brief, is because you don't know what burden to apply. So I think to pick up on the Chief's point, you can't have this be moot and still have that argument.
That is correct. And the board is certainly aware of the reasons why the court should answer these questions. Again, it was more a procedural issue and bringing to the court's attention that the plaintiff, in fact, has passed away. So the board doesn't intend to further argue that case and certainly recognizes the public importance of the questions before the court. With respect to the locus of proof, Your Honor, and as I indicated in the prior case, the issue kind of bled into that argument somewhat. And what counsel did is they were arguing Matthews with respect to due process considerations. And the board's point is that you don't even get there. You don't even get to the Matthews analysis. I point to the Schaefer case, the Supreme Court case that I noted in the board's brief. It says locus of proof is not ordinarily a moment of constitutional importance. So you don't get there. What you need to do is you need to look at the statute. You need to look at the regulation, which has the force of law, which has deference of a statute. And in this particular case, with respect to termination proceedings under 178G, and with respect to offender-initiated reclassification proceedings under the board's regulations 1.31, that burden is specifically placed on the offender. And not only that, in this particular case, the statute and the regulation specifically place the burden on the offender. Even if you didn't have that, you would still go to the ordinary default rule where the locus of proof would fall on the individual who brings forth a suit, who seeks to change the status quo, and as a practical matter, who has more access available to get the information to put before the board. I would suggest that is the argument with respect to the locus of proof. I know Ronald R. was brought up earlier as well. I don't see a difference between the issue at that case with respect to juveniles being relieved pre-process and individuals who are seeking to be...
Isn't the difference in Ronald R. is that when this happens to a juvenile, they're standing with their lawyer?
In terms of right to counsel, I suggest that's a separate and distinct argument.
Because here, you've set eligibility requirements, right, for termination and reclassification.
Correct.
Once those eligibility requirements are met, and they now have a ticket to play, so to speak, that's when counsel comes into play to marshal the evidence and to establish why there should be a termination or reclassification.
It pains me to say this as an attorney, and the first inclination is to say that there is importance in having counsel representing these individuals at offender-initiated reclassification hearings or offender-initiated termination hearings. I note firstly that the appeals court has indicated that the right to counsel does not pertain to these type of proceedings. And I would suggest that implicit in that decision is the due process implications. I would suggest that when the appeals court made that decision, it was considering the due process implications, and therefore they still said that right to counsel would not apply.
Don't those appeals court cases say there's a statutory right, so we don't need to decide whether there's a constitutional right, or do they actually say there's no constitutional right?
If my memory serves me correct, I don't think they necessarily said that there was a statutory right. That way we don't have to apply the constitutional analysis. I could be incorrect.
I thought they concluded you do have a statute. I don't know. We can look at them, because I think I wrote one of them. But
I don't recall specifically, Your Honor, but my memory, as it serves me, indicates that they would have considered the constitutional issues and specifically said that the right to counsel doesn't apply as a constitutional manner with respect to these particular proceedings.
So your position is that Section 178 L3, the reclassification statute, your position is that doesn't apply when the sex offender registrant is moving for reclassification?
Yeah, well, it certainly wouldn't apply for terminations because terminations are covered under 178G. With respect to 178L3.
Right. Are you saying that, because if you're saying that it does apply, then there's a right to counsel in the statute, isn't there?
I'm saying it does not apply, and
Okay.
that's the board's position. That's what the board's position
come?
was before the Superior Court. There are several things. First, I think you have to look at the review of the language of the statute. Chief Justice Gantz had an opportunity to review petitioner and offender-initiated hearings, reclassifications hearings, on 3 separate occasions. The first was so in 2013, the second was in 2014, and the third was 326573, which was just last year. In each case, Chief Justice Gantz did not cite to 178L3 when talking about offender-initiated reclassification proceedings. No point did he say that. Other than that, you have to look at the unambiguous language of the statute. Look at the heading of the statute. It has to do with board classifications. Reclassification is the last word in the heading of that statute. But if you look at 178L1, 178L2, and 178L3, you'll look that they are all consistent, and they all have to do with board-initiated classifications. 1 and 2 have to do with the original classification process, and 3 has to do with board-initiated reclassifications.
Right,
Then you have to...
So we've decided, the statute provides for counsel in the original proceeding, right? It's required.
Correct.
It's required. And why as a logical matter would counsel be less necessary at a reclassification proceeding? The stuff is still complicated, right? I mean, it's...
And if I could just answer that question in 1 second, Ron, just to get back to the language of the statute, which I think is very important. You look at the first sentence of the statute, board may reclassify. You go further into the language of the statute, it says, information that leads the board to seek reclassification. You go further into the statute, and it says, the offender challenging the board's reclassification. And finally, if you look at the last sentence in the statute, it says, if an offender doesn't appear, the board's reclassification may be final. I think it's of important note that in nowhere in that statutory language does it say offender-initiated reclassification.
But I think your
You only find that language in the
sister's going to
regulations.
stand up right and say that they're expecting you to initiate it when the classification is no longer good, in Justice Budd's earlier question, which is that you want to correctly classify people, so you're going to initiate them. Isn't that the argument on the statutory language that...
Just from a common sense standpoint, Your Honor, I respectfully suggest that that's almost possible for the board to go back and revisit each and every case every so often. The board deals with hundreds, if not thousands, of cases over the years. To suggest that we have to recycle every single case 3 years to re-review them...
Well, they're not... I mean, it's the combination that the person waves their hand and says, I want to be reclassified. You created this reclassification process, right? You've done it by regulation.
That is correct, Your Honor.
So you did it. They have the right to do this. And then the question is, so we're going to have these people who aren't you know, without counsel, take on this reclassification process, which you say now they have to establish by clear and convincing evidence? I mean,
I think that's two separate questions. One is the right to counsel, and one is the statutory language question. I think if you look at 16748, which we've already discussed in terms of the footnote, and that case specifically stated that it was only applicable to board-initiated reclassifications, which under the regulations at the time was sections 1 and 3.
But the statute doesn't have any, in response to the chief's question, you've conceded they've got to have a right to be reclassified. They have a right to ask for reclassification.
They do. The
The statute doesn't provide anything about that, right? It's silent.
statute is silent with respect. At the time of 16748 was decided, the statute was silent to reclassification. The decision in that case specifically said that the downward reclassification proceeding was fine. You don't need to touch that. And the last sentence of that footnote basically told the legislature, if you want to conduct upward reclassification hearings when an offender has not been convicted of a sex offense, you legislature, you need to go change the statute. And what do you know? Less than 1 year later, in July of 2013, that statute was changed. And that statute was changed with the language to indicate that the board could conduct upward reclassifications for offenders who have not been convicted of a sex offense. Now, with respect to, I'm sorry, Chief Justice. To answer your second question, in terms of right to counsel and the complexity of these proceedings, I would suggest that's not necessarily the case. And a good example of that is this particular case in and of itself. In the record appendix, you have the hearing examiner's decision in 2006 when the offender was being originally classified, and you have the hearing examiner's or the hearing panel's decision in 2013. In one instance, you have an offender who was represented by counsel. In the reclassification hearing, he was not represented by counsel. In the first hearing, the right to an attorney, with the right to attorney and the attorney present, he presented as terms of evidence one laborer's card, and he called the offender to testify. With no attorney, you had no evidence, but he wasn't working at the time, so he wouldn't necessarily have had his laborer's card, and he testified. So in terms of the overall proceedings, I think it's overvalued with respect to the necessity of counsel. These cases are informal proceedings. Therefore, the offender is to come in and have an opportunity to show the board what has changed, okay? There's no board attorney present in these cases. It's just the hearing examiner, in this case the hearing panel, and the offender. They have the right to retain counsel, the constitutional right to retain counsel, which is certainly different than right to appointed counsel. They have that right. They have the right to bring in witnesses if they want, and they have the right to bring in documentation if they want. As a matter of fact, that is contained within the correspondence that the board sends to these offenders. And then what is the offenders just come in and say, I'm stable, I'm employed, I'm working, I have friends in the community, I'm seeking treatment. There's no cross-examination of these individuals from board counsel. There's no presentation of evidence from the board.
The board isn't represented by a lawyer in these proceedings?
No.
So the board conducts the hearing and it's just one person standing before them? Is that how it works?
It's changed somewhat. In the initial proceedings, the board would do a review on the papers. That changed, obviously, with Judge Wilkins' decision, and then a hearing panel was created. Daniel Noe was actually heard before a hearing panel. It was a social worker, a victim advocate, and a psychologist who were board members at that time. And right now, I believe when we resume these hearings, I believe the board is going to go back to one hearing examiner. So at that point in time, it's going to be the board hearing examiner and the offender. And if the offender chooses to bring counsel and authorized representative, they certainly can.
So the
and if the
board-
offender chooses to bring witnesses, they certainly can too.
So there's no one on the opposite side arguing the opposite case?
I am board counsel, and I have not been to a petitioner offender-initiated reclass proceedings in my years with the board.
Now, the board has come to the view, pursuant to its regulation, that it only has the power under 178L to increase the level.
Correct.
But 178G, and in 178L, there is a right to counsel by statute.
By statute, correct.
178G says the duty of a sex offender required to register pursuant to this chapter and to comply with the requirements hereof shall, unless sooner terminated by the board under section 178L. So in 178G, they recognize apparently that the board has the power to terminate somebody under 178L. But the board has taken away, but the board has said, no, we're only going to be increasing. How do you comply with 178G by having no possibility to terminate your sex offender status under 178L, where 178G recognizes that possibility?
Certainly, and I would suggest that applies to 178L1 and 178L2 with respect to original classifications. With respect to that, you have
It's
individuals...
terminated, though, so you already have to be, it speaks about the duty, so there's no duty to register unless the duty has been established pursuant to the initial classification.
In terms of termination, Your Honor, obviously an offender has been determined to be classified as a sex offender.
Right.
But they can also bring motions for termination during the classification process. So it kind of morphs into a motion for relief. Sometimes people will motion the board for termination prior to the original classification finalization, prior to the hearing. Under the regulations, for motion for relief from registration, those motions for terminate would translate into motions for relief. So it's not uncommon, it does happen with some regularity, that motions for termination and motions for relief from registration obligations will be confused. The board considers those motions for termination prior to a original classification hearing as a motion for relief. It doesn't necessarily mean that the board discards those motions, but the board certainly does handle those motions with respect to the motions for relief.
Now, when there is a reclassification hearing, I assume the person is permitted to submit written documentation
Correct, Your
to
Honor.
be considered by the hearing examiner.
Correct.
And that would be setting forth whatever sex offender treatment the person has had, arguably a letter from the person giving that treatment,
Among other things, yes, yes.
as well as other records perhaps from other individuals with regard to that person's reduced risk of sex offending.
Correct.
But the nature of the people who are going to be applying for it are going to be mostly older, mostly homeless, and mostly unemployed, and homeless and unemployed in part because they're level 2 or level 3. So how realistic is it to expect them without counsel to be able to provide you with the documentation that would be persuasive in demonstrating their low risk of sex offending?
With all due respect, Your Honor, I think that's a dangerous sweeping generalization with respect to that all offenders are homeless.
No, I didn't say
or-
all.
I think you said a great majority.
What share of them are homeless?
I think there's a lot. If you look at just the offenders...
And what share of them are unemployed? I mean, do you know?
For example, the offenders contained in the Doe et al. Case, 17 of those offenders are working. A great many of these offenders are working. I respectfully suggest, as I like to call it, that's the big lie, that's the big myth, is that most of these individuals are unemployed and homeless because of the sex offender registration laws, when in the reality of the situation is that these offenders can get jobs if they so choose. It's just like anything else in life. If an offender wants it, the offender can get it. Many of these individuals come before the board employed, stable, with treatment, and that's what the board wants to look at. So to suggest that because an individual is put out on the internet or has their information publicly available, they cannot get a job and that they cannot find housing, I would respectfully suggest that it's a little bit inaccurate.
Okay, so what if you have individuals who are homeless and unemployed and elderly and arguably ill and arguably have some emotional challenges? Realistically, what is the realistic opportunity for them to be putting together the documentation that I just described to be persuasive?
I mean, It's hard because these cases are so individualized. For instance, if a gentleman is homeless, that doesn't necessarily mean that he'll have cognitive limitations. If an individual has cognitive limitations, that doesn't necessarily mean that he has an individual who can help him and assist him in doing that. If a person has been deemed mentally incompetent, that doesn't necessarily mean that he might not have a guardian or a ward to assist him. So it's really hard to say in a general sweeping circumstance to say, what can these individuals do? If a person is homeless, just because an individual is homeless doesn't necessarily mean he might not be on probation. If he's on probation, he can get information from his probation officer. If he's on probation for a sex offense, he might be able to get sex offender treatment. His homelessness doesn't necessarily forestall him from getting any type of treatment. So there are avenues for these individuals to get this evidence from the board. In terms of a procedural safeguard, I don't necessarily know if you need the right to counsel in these things. Maybe the board could alter its correspondence to suggest that these individuals can bring in witnesses, which I think in the record appendix, it's 104, the correspondence.
Hey, can I ask about how the attorneys work in the system? So these people obviously had attorneys provided by the board the first go-around. They had a right to an attorney paid for by the state, right?
Correct.
And then they disappear because there's no ongoing relationship. So we have, how many people are we talking about? 700? I can't remember the number now.
If my memory serves incorrect, I think the figure that is currently in place, I think as of May of 2017, which is 11 months ago, it was close to 700.
So we have
And since that time, the numbers have almost doubled in 1 year to the current. I think it's 1152 or something like that.
So we have 1,150 of these cases without, if you lose the counsel argument, so you have 1,150 people entitled to counsel. How is counsel selected for this? Is there, I'm just trying to, again, practical realities of what we're being asked to do a little bit.
And that's a problem, the practical realities, Your Honor, in terms of the administrative and fiscal burdens that are going to be placed not only on the board, but on the government. And the government has an acute interest in preserving its treasury. And for these cases that are not that complex, to suggest that we're going to present attorneys, not only for the 1,100 now, but for every single sex offender who comes before the board every 3 years, I would suggest that those funds tend to get astronomical very, very quickly. Not to mention the administrative burdens on the board. As Your Honor pointed out, if this court changes the burden and puts the locus on the board, all of a sudden these hearings become full-blown original classification hearings all over again, which certainly was not the legislature's intent, and it was not the board's intent when we came up with this reclassification process. Board counsel will have to go to these proceedings because we're going to have to carry the burden. We're going to have to cross-examine the witnesses.
Can I ask on the hearings we reordered, so you provided counsel for all of those 500 people for the last case, right?
I'm sorry, Ryan, I didn't catch that. I
Sorry,
apologize.
when we changed the burden of proof, you provided counsel in all of those cases, right?
I believe I'm not 100% positive, but I believe there was a recalculation in terms of indigency for those individuals. There were a certain number of offenders who had previously retained private counsel or authorized representatives, so certainly in those cases, they weren't given new attorneys. But once
So
those
only if you're found indigent do you get the right to a lawyer for these proceedings.
And that's another problem, is that the board actually is processing these indigency requests. So there's additional administrative burdens in terms of doing this. But yes, all the indigent offenders on those 383-16 remand hearings, that indigency status was reexamined, and then for those who qualified at that point in time, then they were also given counsel for the remand hearing, so to speak.
All right, thank you.
Thank you very much. Thank you for your time, Your Honors. I appreciate it.
Ms. Frame?
Good morning. May it please the court. Kate Frame on behalf of the plaintiff, Daniel Moe. Reclassification, the process by which a registered sex offender may come back before the board some years after his initial classification and obtain a lower classification level, is the only mechanism that protects the offender's constitutionally based rights when the passage of time has both reduced the offender's risk and reduce the board's interest in regulating the offender. Given the critical importance of reclassification to both the fairness and the effectiveness and accuracy of the sex offender registry, it makes sense that the legislature, in enacting Section 178L of the board's enabling statute, authorize the board to conduct reclassification proceedings.
So you take the position that 178L3 does apply to the registrant?
Yes, yes, Your Honor.
And the
correct,
most
Justice
recent case that we had on this last year, I think, dealt with whether level 2 sex offenders had to be reclassified as far as internet dissemination. I think that's the most recent
Are
case.
you referring to Doe 326753, Your Honor? Or-
I think so. The one that Chief Justice Gantz wrote, and the level 2 that maintain level 2
Yes,
cannot, they don't have to register.
yes,
Okay, in that case, that's a reclassification case.
yes.
Is it sort of implicit in that case that, that L3 applies more broadly?
Yes, exactly, Your Honor. In fact, this court expressly found in Doe 326753 that that the board's enabling statute permits it to either raise a classification level or lower a classification level upon receipt of information indicating a change in risk. And the court observed that the board in its regulations hasn't recognized that. But the Superior Court's interpretation of 178L3, and as you pointed out earlier, 178L3 also requires that the hearing be provided in a reasonable period of time, in addition to providing expressly for appointed counsel. And the Superior Court's interpretation of that statute as applying both to proceedings brought to increase a level and proceedings brought to decrease a level is supported by the language of the statute, it's supported by the overall purpose and structure of the sex offender registry law, and it's also supported by the decisional and regulatory context in which the statute was enacted.
No, I'm sorry, but practically speaking, in your view, when does the right to counsel attach?
I believe I would argue that the right to counsel would attach at the time that the hearing is scheduled. And I think that
It would have to be initiated by the registrant. It would have to be initiated by the sex offender by filing, by being eligible and
Well-
filing, and then counsel attaches?
I would argue that, and that is one of the questions that I think is somewhat left open, is there a right to counsel before you file that petition?
That's trying to get your position on that.
Yes, and I've thought about that, and I think it could go, I think that, I think a reasonable approach would be to require some submission, some indication of a meaningful change in circumstances, which is what is required in the care and protection of error case that the Superior Court relied on here. And that once that indication of a meaningful change in circumstances is provided, that counsel be appointed. Of course, counsel could supplement that petition if necessary and could represent the individual at a hearing.
Right, so you're not arguing for a general right to counsel where CPCS would have to screen, et cetera. This is initiated by the moving party, then counsel, and again, I would assume counsel would supplement or refile.
I think it could go either way, but I do think it would be reasonable to, upon this submission, which of course could be supplemented by counsel. And I think in some of the cases where, in one of the briefs submitted, in the veterans brief, they cite the LB case, where there was a right to counsel found in another civil context. And of course, the court there found that, the individual should have to come forward before counsel is appointing with some meaningful indication that there's been a change in their circumstances.
Kids' cases, don't you lose the right to counsel? I mean, if your rights are terminated in a DCF case, you don't have counsel after that, do you? I mean, Aaron's a 119 case, right? It's where somebody still has parental rights. The analogy I find hard to follow a little bit, but you lose rights, don't you, in kids' cases? You lose the right to counsel eventually?
Well,
If your rights are terminated, you don't just get a lawyer to keep coming back and coming back and coming back.
You're entitled, when a child, in LB, which addresses the guardianship context, you're entitled to counsel under this court's decision in VV, which was, I think, in 2015. There's an entitlement to counsel when the state is trying to place a child in guardianship. You also get a right to counsel under the LB case, which was decided the next year, when you come back and try to either modify the guardianship or remove the guardian.
Yeah,
So you're making an analogy more between the guardianship cases and the termination cases?
Well, I believe that that's another civil context in which there are significant constitutional rights at stake, where where there was an initial determination that implicated significant and substantial constitutional rights, and the individual is coming back for a reevaluation or redetermination. And at that time, the same constitutional and liberty interests that existed at the initial classification are still in play. And that's relevant to both the burden of proof and the right to counsel. But, the rights that exist at, one of the reasons why, and clearly the statute provides expressly for the appointment of counsel at these proceedings. The language supports that. The statute, even before we get to the constitutional issue, the statute provides that reclassification, it applies by its terms to reclassification broadly, not just to board-initiated upward classification, which is what the board argues.
But you say that, but the statute says the board may, on its own initiative or upon written request by a police department or DA, seek to reclassify. It doesn't speak about the offender seeking to reclassify.
That's correct, Your Honor, but in the context of a petition for reclassification filed by an offender, the board's initiative is in response to the petitioner's motion. And I think if you read 178L3 too restrictively, that would suggest that only the DA and the police could submit information to the board that would initiate reclassification proceedings, when in fact, if you read the section together with 178K4, the board is required to share information with a broad range of other entities. And that's a non-exclusive list of law enforcement agencies such as DCF, not only the police and the DA, but DCF, the Department of Corrections, the Department of Probation. The board has an ongoing statutory duty to share information that is relevant to not only determination, but reevaluation of risk. 178K4 refers expressly to reevaluation of risk. And so the board argues in its brief that the petitioner is in the best position to provide evidence that his risk has decreased. If that is the case, and the petitioner is certainly one of the important sources from which the board should receive relevant information and act upon that in initiating a reclassification. The board doesn't always initiate reclassification proceedings in response to a petitioner's motion. In Judge Wilkins' decision, he noted in 2012, which is in the record, there were, I think in 2011, the board received something nearly 400 petitions for reclassification, and they screened out, I believe it was 160, I may not have the exact number, but they screened out a great deal of them because they were not eligible. And again, they indicated in that case that some of those people came back and addressed whatever the ineligibility was or waited until they were eligible. But the board doesn't always initiate in response to that. And I think if you look at the decisional context in which the legislature enacted 178L3, the board argues, that Justice Cipher's decision in 16748 suggests that the statute was enacted only to allow the board to increase the level. However, in the footnote in that case, Justice Cipher stated that reclassification downward is very important to protect an offender's rights. And I think what the court was saying in that case, if I may presume, was that, we're not touching that aspect of the board's regulations. We're not suggesting that the board does not have authority to lower a level. We want to point out that that's an important part of what makes this classification process constitutional. Additionally, 16748, several months after that, Judge Wilkins decided 17501, in which he found not only that there's a constitutional right to a hearing on reclassification, but that there's actually a right to a redetermination after some period of years when a person has been...
Interestingly enough, Ms. Bova said that there's a footnote in that case suggesting that there wouldn't be a right to counsel.
I believe the footnote simply states that in that particular case, there was an attorney and which is largely why that issue was raised probably and brought to the Superior Court so effectively. There was an attorney in that case, and he said, indeed, that may be unusual. And that may be, I appear at many reclassification hearings, and I can't say what happens at those. I know Attorney Tennant does as well.
So
And-
your brother argues that this is different from those kids' cases or a criminal case where there's a lawyer on the other side. It's just the board and the person. Why shouldn't we find that persuasive?
Well, I think that additionally, to address the rights, when you compare the rights to the cases involving custody and guardianship.
Again, but there you're opposed, you know.
Oh, I see.
There's, DCF has a counsel there. In criminal case, you've got a prosecutor. It is the board, I mean, I understand it's complicated, but it is like, there's not another person on the other side arguing against you, is there? There's not a prosecutor in place.
There isn't as a technical matter. I mean, if you look at the record in this case, you'll see that there was a panel, who's homeless, appeared before a panel of 3 governor-appointed board members, and he was aggressively cross-examined at points in that hearing. And it was a tall order for an individual who's.
You're saying the board is the equivalent of the prosecutor as well as the judge in these cases?
I think that if you look at what happened in this particular hearing, and I think board.
Not so much focused just on No's case, but the process, because you're basically saying there's a right to counsel in all cases, right? You're all cases in every reclassification, and I'm just trying to get a sense, because that's a significant, maybe it isn't a significant burden, I can't tell, but now we're talking about 1,200 cases, 1,200 lawyers, 1,200 proceedings, so we're talking about a significant, I just want to make sure it's necessary, right?
Right, well, in terms of I can address the cost as well, Your Honor, but in terms of the necessity of it, reclassification involves the determination of complex legal and factual issues. It involves the application of the same 30-plus factors that the board applies at the initial classification. Those factors rely on research, which is complex. This court found in Doe 151564 that an expert is required to properly interpret the research on age. And so an attorney, the clients of CPCS, and again, not all of the 1,200 will be indigent, certainly, but the clients of CPCS typically have disadvantages that make it difficult for them to advocate effectively on their own behalf, and the advantages that go beyond their immediate poverty. Many of them, as the Chief Justice pointed out, are homeless and unemployed.
But you're not individualizing. You're saying everybody. So we've got to decide it for everybody, right?
Yes, and the reason it's necessary is really for the same reason it's necessary at an initial classification, because of the complexity of the task. Predicting risk is not a simple task. It involves weighing multiple factors. It involves understanding research. It also involves understanding the board's legal procedures that are set out in the regulations. There's a requirement for an affidavit. An affidavit, just to sort of get in the door, there's a requirement for an affidavit if you're going to establish that you have a medical issue that's relevant. And if you look at what happened in this case, I think it's what typically happens when an indigent person with some of the limitations they may have, whether it's cognitive limitations, mental health issues, or physical issues, illiteracy. No in this case didn't call any witnesses in his behalf, didn't present any documentation. He was uncertain whether he should testify. And so I think that the additional procedural safeguard of appointed counsel is really important here, given the rights at stake.
Ms. Frame, we've been asking a lot about right to counsel, and you really haven't had a chance to get too deep into the burden of proof issue. I think your position actually is that the liberty interest is greater as time goes on.
Yes, Your
And that
Honor.
the implications of registration are more serious now than they previously were, and that a lot of these people registered under a
Yes.
different initial standard.
Yes, that's correct, Justice Lowy. And in fact, this court outlined in detail in Doe 380316 the increased burdens and deprivations that sex offenders now face as a result of their registration and dissemination. But in addition to that, you have the fact there's really been a shift in the balance of interest by the time we get to reclassification, because the offender, by definition, these are people who have been offense-free in the community for a period of years. They haven't reoffended. They can't even apply until it's been at least 3 years. And so because of that, their interest in a lower reclassification, or their interest in a reassessment of their risk, of whether they continue to pose their risk, is heightened. At the same time, the board's interest in regulating them has gone down. The research that we cite in our brief, in Hansen's research in 2014, High-Risk Sex Offenders Are Not High Risk Forever, is the title of the article, and he found that every 5 years, risk declines by 50%. Those findings were further solidified in 2017 recently, where Hansen and his colleagues observed that, that certainly at the initial, when someone's immediately after release, immediately after conviction, those static factors, the ones that relate to their offense and victim characteristics and as such, are certainly relevant. They continue to be relevant as time goes on, but they're time dependent. They become less relevant.
No, counsel, those statistics you're referring to, do they take into account any difference between people who are registered as sex offenders and people who are not? So, in other words, does the sex offender registry process contribute to their being offense-free?
They don't specifically. Actually, what Hansen recommends in his 2000 and his colleagues recommend in the 2017 study is that because the decline in risk is so significant, it's important for state agencies to have a mechanism by which a person can get off the registry after some number of years. There's also research, to address your question perhaps a little bit more directly, that's cited in the amicus brief submitted by CPCS that shows that overclassification actually increases risk by increasing instability. I mean, if you look at Noah's situation, he was homeless. If his level had been lowered, he would have had a place to live. He would have been able to live with his father.
Can I ask you, you mentioned costs, and we
Yes.
have to contemplate 1,200, 1,100 appointments of counsel.
Yes.
If we do that, are we also going to have next year a case where counsel comes in and says, well, we need expert witnesses because we're dealing with risk assessment, and to be effective, we're going to have to get public money to hire expert witnesses in all these cases. So the informality that we're seeking to expedite these hearings on this backlog now become an adjudicatory hearing based on that Superior Court decision that wasn't appealed. Now we're going to have counsel, and I'm not saying that's a bad thing. Now we're going to have counsel, and then counsel says, I need money for an expert witness. Is that what we're buying as well?
Well, we have a lot on our plate today, and I hadn't quite thought about that. But what I'll say is that certainly.
I think we have to, though, when we talk about.
Yes. I guess to address the cost issue, first, as my brother, Attorney Tennant, suggested to the court, before this requirement of a hearing went into place in 2013, the board would review petitions for reclassification and termination on paper, and there wasn't a backlog at that point. Perhaps a solution is to triage these cases, as Justice Cipher suggested. Man, for example, one of our plaintiffs in Doe, who needs medical treatment, and he's in his 70s, and he can't get medical treatment he needs, and his offense was 30 years ago. Let's triage that case. Let's take him off the registry so he can get the medical treatment he needs. And maybe we can do that on paper without a hearing. Do we really need a hearing on that? If the person doesn't obtain the relief they're seeking, then perhaps, we need a hearing, and we need counsel, and then counsel would address. But I can tell you, many of the people that I represent, and
But I'm confused, though. So you're saying you only get counsel if they contest the reclassification? So it's not a right to counsel unless they contest it?
well, I'm crossing over a little bit and talking about the delay issue, and that one way of dealing with the 1,100 cases that have filed petitions is for the board to review them on paper and determine whether they would allow those petitions on paper without a hearing. And so I think,
How about in the opposite?
Actually, if you
Oh,
could
no, go
finish my question. The question was, you're appointed by CPCS on one of these cases. Is the next thing you do when you appear to file a request for funds for an expert witness?
I can tell you what I do in many of my cases, and many of the people who apply for reclassification, if you look at the profiles in the Doe case, they have been offense-free for, the vast majority of them have been offense-free for 10 years, some of them more than 20, some of them more than 30. I will tell a client, you don't need an expert because you've been offense-free for 20 or 30 years. There are many, I find that most of the people that come up for reclassification, it's really not something that requires expert testimony. So I can't tell you.
Those are all privately retained cases, I assume.
Yes, and when the board observes that some of those people have jobs, yes, they are sort of by definition, they were able to hire private counsel, Mr. Tennant or myself or Mr. Crouch, and so they're not indigent. But certainly, I don't always use an expert at a reclassification hearing. But I think that the point more is that if there's a constitutional right to the reclassification, then the cost of it is not a reason to deny the right. But I think when you look at the cost, you also have to consider that there's a right to counsel at the 30A when the individual appeals the hearing. So that has additional costs built into it. I can tell you that this case entailed, no, didn't have an attorney at hearing, but I have been litigating his case now for 3 years. And there was an expense to the state for that. And
When you said there was a right to counsel at the 30A when they appeal, is
Yes.
that the appeal from the initial reclassification, or are you talking about an appeal from a reclassification?
also, there's a right to counsel. I was appointed to represent no in this case because there's a right to appointed counsel when you appeal a denial of a reclassification. So, and one of the problems with that is that the Superior Court then has a very limited record, because as you saw here, the board based its decision on an old, cold record, which is one of the problems when the board doesn't have any burden. They based their decision on Doe's initial classification and then an updated Board of Probation record. And Doe didn't have the wherewithal to offer any evidence or documentary evidence on his behalf or to call any witnesses. And so the problem here is that when you get to Superior Court, you have an extremely limited record. And I can tell you that under 30A, there's a procedure that allows the counsel to file a motion to submit additional evidence. And I can tell you that that's something I will do in one of the cases if I'm representing somebody. Excuse me.
So what you're saying is, if you win and the person is no longer classified, there will be a cost savings at some point.
Right, there's a cost saving. And what counsel does is it ensures a more accurate classification. It doesn't only help the petitioner advocate for himself, it helps the decision maker make a more accurate decision, which is in the board's interest. Overclassification is not in the board's interest. And the expense, additionally of that, I mean, the expense to the state, I have level ones that the police have to come and check on them regularly, their address. And I have one client, they did that last week. He's been offense-free for over 20 years, has had no offense history. And the state is spending money sending the police, to check to make sure that he's still there. And so there are costs to continued regulation of individuals when they no longer pose a risk that justifies the continued regulation. And so, again, the cost.
The statute, what provision provides you the right to counsel for the 30A hearing?
178M, Your
Sorry,
Honor.
it's what?
It's 178M. And I will say that one thing an attorney can do, which is one of the things I have done in cases on 30A, when I didn't represent somebody at the hearing and I'm hired later on, is you can file a motion to submit additional evidence in the Superior Court. And I think what you're going to see attorneys doing, and Noe was one of the first appeals of the denial of reclassification because he had his hearing very soon after the right to a hearing came into effect. But what you're going to see attorneys doing in the Superior Court is filing motions to submit additional evidence. What happens under 30A when an attorney does that is the case then goes back to the board, and the board is ordered to listen to this additional evidence. And that's the thing I would do in the next case I get, is say, Your Honor, there's no evidence here because this individual, he's homeless, he doesn't have a computer, he couldn't write a letter, he didn't know he could call witnesses. So we need to go back to the board and submit to them all of the evidence that I would submit, and then we can come back to you and you have a record in which you can make a decision and properly review this case.
If I could go back to a question earlier asked by Justice Gaziano and something you said. I'm trying to understand your position. Is it your position that once an offender meets the burden of production in the regulation, Just say
Yes.
that you've been offense-free and you meet the various criteria.
Yes,
That once you've met the burden of production, then the board under 178L3 must, on its own initiative, provide a reclassification hearing? Is that what you're saying?
Yes, Your Honor.
So you're saying that the offender's initiation of it meeting the requirements of the regulation trigger an obligation on the board to then say, we're going to hold a hearing under its regulations?
Yes, Your Honor.
And are you also saying that the offender's satisfaction of the burden of production would then mean he'd have a right to counsel? Or are you saying that would occur sometime later? I'm trying to figure out when that
Yes, no,
would
I
occur.
believe the offender would at that point have a right to counsel.
So you would say the offender would first have to demonstrate that he or she, usually he, has met the burden of production, and then and only then would the right to counsel be triggered?
Yes, I think that. I mean, I think that indigent offenders may have some difficulty establishing, that burden of production. And so I think that the court could
Well,
find.
that's the problem, but how do you do it without
Yes,
that?
without counsel?
Without a burden of otherwise,
Yes. I mean, I think that's a reasonable, and I think that's what in providing for counsel in some of the other civil contexts, that's what has been required, is that the individual seeking relief come forward with the burden of production, and then at that point, they have a right to counsel, and the board then has the ultimate burden of proving that the person continues to pose a risk. And I also obviously find that even if the statute didn't provide the right to counsel, 178L3, which I think it does, the due process, of course, would require that, given the significant interests at stake.
Meaning like the indigency affidavits that we require people to fill out? I'm just trying to figure out how this would work practically.
Well, the way it would work, there's really a system set up for this already at the Sex Offender Registry Board, because at initial classification hearings, a counsel is appointed. And so what happens is the board sends notice and says, we're going to schedule a hearing, and you can either hire counsel, or you can represent yourself, or you can send us in information establishing that you're indigent. And at that point, the board then forwards the information to CPCS, and counsel is appointed. So this is already built into the process at the Sex Offender Registry Board.
all right, thank you. We'll
Thank you
take our
very
morning
much.
break.